Good afternoon. I'm Jana Martin, Chief Executive Officer of the American Insurance Trust, known to most of you simply as the Trust. We are delighted that you're able to join us virtually today for the next webinar in our virtual webinar series. The Trust is pleased to be able to offer this informative content free of charge to our policyholders. As a Trust policyholder, most of you are likely familiar with our risk management consultation service, the Advocate 800 program. It's one of many benefits our insureds receive through the Trust. Three of our advocates are with us today, Drs. Jeff Youngren, Eric Harris, and Liesl Bryant. In the interest of time, we've placed their bios on a slide. If you didn't attend the Forensics Roundtable in March, then you missed out on my acknowledgement of a very special achievement by one of these advocates, Dr. Jeff Youngren. Dr. Youngren was presented earlier this year with the 2022 Distinguished Career Practitioner Award from APA's Division 29 in recognition of the contributions he has made throughout his career to the advancement of psychology. Please join me in wishing him a heartfelt congratulations on this remarkable and well-deserved accomplishment. I hope you benefit immensely from this risk management roundtable. Please join me in welcoming Drs. Bryant, Youngren, and Harris. Thank you so much.
Great, thanks, Jana, and welcome to all of you. We're delighted to be back with you today. And as usual, we're going to start with a few questions that we have in advance. We'll do about 4 of those, and then we'll turn immediately into the live questions. So as we talk these through, as usual, feel free to go ahead and start typing in your questions in the Q&A. So Eric, I'm going to start with you with the first question. Imagine that you've been working with a 17-year-old female patient in Maryland where you are licensed. This client has problems with social anxiety, mild depression. You've been working with her for, say, about 2 years. She's now going to college in Connecticut and wants to continue treatment, and her parents also want her to continue the treatment, but you are not licensed in Connecticut. The client is going to be back home in Maryland about 40% of the time. And the only other real alternative is to refer her to someone who's licensed in Connecticut. But it would likely be difficult for this particular patient to form a new relationship, and would also mean in some ways that she might have 2 therapists if they both continue working with them. So in this kind of scenario, what would you say are the legal, ethical, and risk management considerations that need to be thought about in order to decide whether or not it makes sense to continue treating this client or transfer or terminate?
Okay, Liesl, thank you for the question. So first of all, let me say that Maryland is a SIPAC state. And this answer is not, and I want to repeat that for everybody that's listening, a SIPAC answer. I couldn't tell you what SIPAC would say about the situation. So we're going to talk as if this person is not the provider is not a SIPAC participant. So many of you may recall that before COVID, people were beginning to talk about interstate practice. When the internet first became an available technology to be used for internet for therapy, the question came up, well, what about, can you only do it in the state that you're licensed in, or can you do it in other states? And it was not an easy question for the law to answer, because an internet transaction actually takes place in cyberspace, which is a place that is not regulated. So what people decided, and I won't go through the long process of how they decided, is that in order for states to be able to enforce their consumer protection laws, transactions would be considered to take place in the place that the client was when the transaction took place. So if I were talking to someone, I'm licensed in Maryland, and talking to someone in Connecticut, both Connecticut and Maryland would assume that that transaction is taking place in Connecticut. Then came COVID. And during COVID, almost all the states created temporary rules that allowed people from out of state that were licensed out of state to practice across state lines with people in that state, as long as there was a medical emergency. And that medical emergency is still happening on the federal level, but almost all of the states no longer are considering that something that you can do without consequence. So technically the answer would be, if you want to take the legal approach, the Maryland psychologist would have to say no. She could only see the client when the client came back home to Maryland. And if she wanted other therapeutic intervention aside from that, she would have to get it from some Connecticut licensed person, or she would have to look around and find somebody that was licensed in both Connecticut and Maryland. However, when the laws have been considered about this, there are exceptions to the rule. The courts have basically said that in order for someone to be able to, in order for Connecticut to take jurisdiction over a Maryland psychologist, that Maryland psychologist would have had to meet what's known as the minimum contacts test. That is, they would have had to be perceived as actually trying to do business in Connecticut, rather than merely extending services to someone who they had been seeing and had a relationship with, who needed the continuation of services in order for their condition not to get worse. So what we've been advising people, and this is too simple, and we certainly encourage everybody in any situation where this comes up to call us and get an individual consult. But basically, our advice is occasionally, and it should be occasionally, this should not be seen as a way of doing interstate practice, going around the rules. So you shouldn't have 20 clients in 20 different states with 20 different good reasons why you need to continue to see them. Because if there is a complaint, that will not go over very well with any of the licensing boards. And you don't want to have to go to court to have this sorted out. But basically what we've been saying is, where you have a client who is appropriate and where an in-person referral will not meet that client's needs for various reasons, and the client really needs to have a continuation of the services, that you can make an exception in that case. So let's look at this case to see what we might turn out. So is the client appropriate? The real risk in these situations is licensing board risk. So the first thing you want to think about with this client is this client, the kind of client who, if I called the trust, they would say, this is a high risk client. Because if it's a high risk client, that means it's a relatively higher risk to the provider if they continue services, partly because they wouldn't be able to, they'd have to really consider how they would manage emergencies. And there are ways to do it. They could get connected to the Connecticut College's mental health clinic or the counseling center, and that might be able to work, but that would be a higher risk than this client presents. This client is not suicidal. She has social anxiety issues. She would have a very hard time connecting with another psychologist, or it would take quite a while to do it. And then she would have the problem of the split treatment when she came back and when she was in Connecticut. And we all know, at least I think we know, that that's not optimal. Certainly, you could say in this case, and this is the test that I generally use when I'm talking to people, is would an in-person referral be equal to or better than your continuing? And in this case, it seemed pretty obvious that an in-person referral would not meet that test. And generally, that's the general general process of risk management we would go through. But if you choose to do it, you would need to have a very carefully documented record as to the thinking process that you went through in order to come to the conclusion that you continue to do this. It would be a good idea to have a recording of in your records of your consultation with the trust. And also it would be good to have a consultation with a local psychologist who is a colleague, because the temptation here when you're working with a client is to say, well, I have a special relationship and therefore it's always superior for me to say to do this than to refer it to somebody else. It's very important to do the rationale. I would also say that we don't have our actuarial data at this point is very limited. It would be very hard in this situation for Connecticut to do anything other then issue what's known as a cease and desist letter. That is, if somebody found out you were doing this and complained to the Connecticut Licensing Board, they would send you a cease and desist letter. And since you probably would already know that somebody had complained, you would probably already have ceased and desisted. The only question about a cease and desist order is it considered to be discipline? Jeff and I don't think it is discipline, but there are people, particularly people who work for AASPB, who think it might be considered discipline. And if it was considered to be discipline, then it could prevent you from becoming a member of SIPAC. Because if you've had past discipline, SIPAC excludes you from being a provider. Again, the point I want to make, and the reason I think you would get a cease and desist letter as opposed to anything else, is technically you would be committing a criminal act by practicing in Connecticut without a license. But in order for Connecticut to do anything with a Maryland person, they would have to first charge you in Connecticut, and then they would have to extradite you. And in a situation like this, that's just not something that's going to happen. I could go into a long, detailed explanation of why that's not going to happen, but you just have to take my word for it. That's it in a nutshell. I think that each individual case probably requires a little bit more discussion. So please, if you're thinking of it, give us a call.
Great. Thank you, Eric. I think it is definitely nuanced, and so it's hard to get in all those tiny pieces. Jeff, do you want to add something there?
Yeah, just briefly, that I think what Eric is talking about is an exception, not a rule. And that's important to be able to separate those, that this is a carefully thought out decision to arguably violate a state law because you are making clinical decisions about it. You've protected yourself through consulting with other individuals and have engaged in risk management. And as, excuse me, as he pointed out, if you have 22 of your patients or clients in different states, that's not an exception anymore. And that's very problematic. You know, every rule, every law in the world has exceptions. There are special conditions, and that's why the law evolves. And this is an example of it. The interjurisdictional issue is one within which I think we all agree we need to solve this, and we're moving in that direction, but we don't have the solution. So Eric's suggestion is right on. It's an exception. You make an exception with this client. It doesn't mean that you can just open up your practice to everyone anywhere because Eric Harris said you could.
Right. Although, go on. I was just going to say, if you read the cases, that's very clear that this is intended to be a very unusual situation that occurs for a good reason.
Yeah, and it's a good point both of you are making, because I know I've heard a lot of clinicians say, well, you know, I can practice, so long as I was seeing the patient beforehand, I can keep seeing them anywhere they go. And that isn't true. And we do need to be careful. I want to say, I'm going to speed things up and heading to the other three questions here, but I do want to just clarify there is a distinction between temporary practice laws, which preceded COVID and are still in place and will continue to be in place. That's the typical state temporary practice law. I think, Eric, what you were referring to is what sometimes are referred to as the COVID waivers. And those came into place specifically related to the public health emergency. And as you said, most of those are now expired. But just to be clear, every state does have a version of the practice law, but every state, they vary. So you really, if you're going to rely on a temporary practice law, you have to look into which state and what's the specifics of that state.
That's absolutely right. But sagely, I want to let you know that I chose Connecticut, which doesn't have a temporary practice.
Yes, well, but they say they will handle it on a case-by-case basis. So
Right.
depends how we define that. Okay, Jeff, moving to you. How then would you recommend that someone handle a patient who travels frequently for work? Say a truck driver who's going to be in a different state every few days. What would a therapist do in that case?
They need to get licensed in all 50 states so they can avoid a problem.
Careful.
Of course, that's a stupid suggestion, right? I mean, this is a great example of a case that doesn't fit into the rule system. It just simply doesn't work. I mean, if somebody plays in the Marine Corps band and they're traveling all over the country and they're in treatment with you, same problem. So you really want to engage in a careful analysis of the case, implement some emergency strategies, and make a decision about whether this case is the exception that you're going to make in a deviation from the state practice laws. Because as Eric said, Connecticut, Wyoming, they're states that are difficult with these kinds of things. And I wanted, before I forget, Eric talked about the fact that the state would have to extradite you. Actually, I think there's only one case where an individual has been extradited for a violation of a practice law, and it was a physician that was extradited. So the extradition is not going to happen. It is going to be the cease and desist letter, which Eric and I both agree is, I don't think it's discipline. I think it's informative. But I don't want you to be the test case to figure that out. So with this traveling truck driver, you make the decision based upon the kinds of problems he or she has, where they're going to be, how often they're going to be with you. And obviously you can't refer them to a different therapist in every state that they travel to. That's ethically nonsensical. So ethics comes storming in to say that that's a bad decision, even though that's one that might be consistent with the state law. So this is that wiggle room where you need to consider making an exception.
Yeah. Anything quickly there to add, Eric, before we move on?
Yeah, the only thing is, this is one of those things that there's a long continuum that runs from what Jeff's talking about to somebody that goes to Florida for a month in the middle of the winter.
Agreed. Agreed.
And again, it's another one of these things that these are all very fact specific and they should all be consulted about. And there's probably a lot more variables included than we are discussing.
Yes, and the length of time is really important. Like you say, are they going to be out of state for a week? We've certainly had calls of patients, saying my patient's going to be on vacation for a week. That's far, like almost no risk as compared to someone who's moving permanently to another state. So
exactly.
Time and the permanency
of it. Justify continuing to see someone through telepsychology who has permanently moved to that other state, and you're going to continue to see them. I would argue that you're opening up business in that state.
Yes, I agree. And I think last point on this case of the truck driver, I think one very good argument for this being a true exception is in fact that they couldn't get therapy any other way. So I think that's an essential case in that. And in some ways that case makes it easier because it's a stronger argument for why you would go ahead and make it an exception. Okay, for time's sake, Eric, I'm going to move on at this point and come back to you with another question. Let's say that you've been approached about working with a couple who are now moving to Saudi Arabia because of the husband's job. The couple has 2 small children and they are divided and conflicted about the move. One of the children is also on the spectrum. What would you say needs to be considered in determining whether or not to provide services in that international family dynamic kind of situation?
Well, actually, what I like to say, somewhat jokingly, but almost for sure, that if you are licensed in New York, it's much more dangerous for you to practice with somebody in New Jersey than it is to practice with somebody in Saudi Arabia. In the 30-some years I've been involved with the trust and this risk management, we've only had one case where somebody was working internationally where there was actually a problem with the license, that person's license. And that person was licensed in one of the states in the United States and was working with someone in Israel at the time and did some really, really bad stuff. And so that was enough to get it done. So by and large, what I would say is the real question here for the psychologist is what's the problem? They want to get some advanced information about what exactly the couple is looking for, because are they looking for help with some behavior analysis around their autistic kid? Are they looking for family therapy? Is this couples therapy because they're divided about the move? You would need, I think, to do some preliminary interviews with them to make sure that it's a good fit for your skills and what they need. But then I think agreeing to do it would not be very risky at all.
Okay, Jeff, any additions there?
Yeah, I think one thing, I'm not sure you bumped into it, Eric, is we don't even know if the profession is regulated in Saudi.
No, I know, no. But even if it
so
is,
it's not regulated in Saudi Arabia.
Even if it was England, I would say this.
Well, there are states where, that's a different place. It is regulated in England. It's regulated in Israel, but it's not as, I don't think it is in Saudi Arabia.
I think
In
it's right.
Mexico, it's got very different laws because people.
But I'm saying for purposes of the risk management of our insureds, there is equal risk no matter what the international regulations are, because in order for there to be any consequence, the state that the overseas state would have to create an international incident. And that's not
right. Your risk is with your licensing board in that circumstance.
And just to bring it all together, I think, for all three of the questions now, we've been looking at, there's multiple factors, right, to consider. One is regulatory. What's the regulatory issue? And what is the risk with potentially violating that if it's a violation, right? Another is length of time the person will be away, or is it a permanent move? Another is the client clinically suitable? What's the clinical risk? And one thing we haven't touched on, but I think should very quickly here, is emergency planning. If a patient is out of state, is certainly out of the country, very important that you have an emergency plan, right? So all of that has to be thought through. And then the last one I'd add, you guys haven't mentioned it, but I just want to concretize it in terms of themes, is billing, insurance billing in particular for these. So I think that's a good rubric to have in mind if you consider each of those things in a nuanced way, case specific, right, to each particular case, and consult, like both of you were saying, then I think you're on pretty solid ground.
Well said. Well said.
Okay, Jeff, last question to you, and then we're going to turn to the live questions. Let's assume that you are a member of SIPACT, but your patient lives in a non-SIPACT state, but that state that they're in borders a SIPACT state. Do you think it's necessary to have that patient drive into the SIPACT state in order to have telepsych sessions with the therapist?
This is a great example of, I think the rule kind of has run into the observant area of thinking. I think we go back to our model. I think it is unreasonable to have your patient drive across the state line and park in the 7-Eleven parking lot to have their psychotherapy session because you're a SIPACT member and that's a SIPACT state. That doesn't feel right to me as a solution. Now, if that patient actually lives in the non-SIPACT state, all of the rules about temporary practice and whatever are the ones that you should address. The SIPACT issue, I mean, the world knows it's not my favorite model, but the problem here is if they live in a non-SIPACT state, your issue are the same as we've talked about. How long are they going to be there? Is that a residence? Can you justify the treatment with that? Do you need to make a referral? Is your intervention the best? And is this a high-risk patient who really needs to have someone in that state taking care of them? Those are the right questions to answer for that client, not like you need to drive to the 7-Eleven. And I mean, you can have the same serious problems with a patient in another state. That's a SIPACT state. So you need to evaluate each case individually and arrive at an ethical conclusion about what the right thing to do is.
Yeah, Jeff. I'm sorry, Eric, any addition there?
No, I think we should move on to the.
Yeah, exactly. Yeah. Okay, great. So we're going to dive into the live questions. This one is on SIPACT, but a slightly different twist. Can you point us to any resource that might help SIPACT psychologists in creating an informed consent that can be used across states? ASPPB did not have any suggestion and pointed us to the Trust's model informed consent. Eric, do you want to comment on that first?
Yeah, I think that's a very hard question because what SIPACT says is that you have to follow the laws of the state in which the client is located in. Mm-hmm. And yet you are regulated in your own jurisdiction. And as far as I know, SIPACT has not figured out a way to inform people what the laws are in the various states. Somebody could call us and we could probably help them in some instances in maybe giving them some suggestions about what the different laws are. But as far as I can see, SIPACT requires a different informed consent for every state that another SIPACT person is in, which is to me is a terrible, terrible problem with the program. And there's some really serious issues. For example, Texas doesn't honor tears off. So if you were to do a tears off warning, because you were located in a SIPAC state where a tears off warning was required, that would violate Texas law and therefore would violate your responsibilities under SIPAC. So I don't know what they're going to do about it, but it, to me, makes it very difficult to figure out how to do that. So I wish I had an easy answer for you about that, but I don't.
I think one of the important things you're saying there, Eric, is to consult and get, there's SIPAC makes a lot of things easier and there's some tremendous benefit, but there are some things that haven't yet been worked out and some potential risk. And so, consulting, especially on particular cases, is important. Jeff, do you want to add anything before we take another question?
Yeah, I think that this is a serious problem because there are states, Texas isn't the only one, New Mexico also doesn't have a tear-us off. And so we really need to look to ASPPB to sort these issues out. I mean, I would also refer the questioner, we do have a telepsychology informed consent on our website that you can modify, but the problem with it is that as Eric pointed out so correctly, it needs to be modified for each individual state where the client or patient is, because the rules are different and the rules still conflict with your rules. So could the state, if you're in Georgia, which is a SIPAC state, and you're delivering services to Washington, which is a SIPAC state, and the laws there conflict, I mean, what do you do with that? You choose one, you violate the other. You choose the other, you violate the first one. This has to be solved.
But I think there's a bigger issue, which is how do you find out what the law is?
I agree.
I remember when we started this program, before we were willing to do any consults at all, we hired some lawyers, we took 6 months, and we built a database for the 8 questions that were most likely to be asked of people. And if people asked the question 11, we wouldn't give them advice because we couldn't be confident of the advice that we're given. I think SIPAC didn't think that through in advance, and I think it's a terrible weakness of the program. I don't have an easy solution.
Well, yeah, I think that you're correct. As we did that years ago, I think before time started, that the laws were very different. You would see when you did the consult, you pull up the law in Illinois on record keeping. Well, that law is different than the record keeping law in California, and that is not resolved yet.
So the simple answer to the question is no.
Right. It's no, and I think that one of the important things to take from this discussion here, this part, is that if you are a member, if you have an e-passport and you're practicing under SIPAC, you need to be aware of these issues. You do need to try to find out about the laws in the other state. And this is absolutely one case where we would say, give us a call and consult, or consult with attorneys in those states, whatever, there's no easy answer, but you absolutely want to be aware of the complexity and the issues. Okay, moving to a different question and even a different topic. Is it possible to start a coaching practice while continuing to have a psychotherapy practice? Does the trust malpractice insurance cover coverage for coaching? And can you confirm that state licensing restrictions would not apply to a coaching practice? So that's technically 3 questions. Eric, this is your sort of area of expertise, so I'll go to you first and then Jeff will come back.
Let me answer the last question first, which is, the fact of the matter is psychologists are licensed not to provide psychotherapy, but for the practice of psychology. Coaching, by and large, oversimplifying it, is counseling psychology in new wine and new bottles, really. So if you start a coaching, you certainly can have a coaching practice and a therapy practice, that's fine. But the coaching practice is subject to the same rules that the therapy practice is, or similar rules. We happen to, if you're interested, on our website, called an article that I wrote called Coaching, the New Frontier, which goes into this in some detail. And also there is a informed consent for coaching. But the idea that coaching is somehow different than the practice of psychology, and therefore you can do things as a coach that you couldn't do because you're licensed as a psychologist, is a myth. I don't know who created, but certainly it wasn't us.
Mm-hmm. Jeff, any addition there?
Absolutely. I mean, first, too many people think of that coaching as a way to avoid the oversight of a licensing board. They really, somehow, they've convinced themselves that if they call themselves a coach, then the Board of Psychology can't regulate them, and they're entirely incorrect. That's not correct. And the second thing is they want to do the very same thing that they did as a psychotherapist with the coaching client, but they're just going to call it coaching. And I think Eric would say, as I've heard him say many times, if it walks like a duck and looks like a duck and quacks like a duck, it's a duck. So, just suddenly, taking on the mantle of being a coach, and therefore no one can make me accountable for what I do, is a nonsensical death wish.
I've also heard people similarly saying, well, I'm going to keep doing therapy, but I'm going to call it consulting, and therefore I can cross state lines, which is the same thing, right? So it doesn't matter what you call it. If you are doing the practice of psychology, and that is broad, as you both know, right? The state laws that define the practice of psychology intentionally define it broadly, right? It covers a lot of things. And in most cases, coaching is going to fall under that.
And even regulates calling yourself a psychologist. So I guess I would say that there's no limit to the creative mind.
Well, there is a way you can do it, but you have to make a choice. You'd have to give up your license and decide that you're going to be a coach and not a psychologist anymore, and all of that education and everything. Well,
but be very careful not to call yourself a psychologist.
You can't call yourself a psychologist.
Correct.
Yes, exactly.
I do want to just clarify, the other question was, does the trust cover coaching? And the answer to that is yes, it does. Yeah. Just to be really clear about that.
Because it is the practice of psychology.
Right.
That's what we cover.
Exactly. Here's what I think is a quick question. Should we get separate telehealth cyber insurance if we are using a HIPAA compliant platform such as Doxy? Jeff, you want to dive in on that first?
I don't think that's necessary. I think that, we oversell insurance. I mean, first, the likelihood of anything happening to you is relatively small. The malpractice cases are extremely rare. The big problems we have are not liability cases, but are board cases. And that's where, and you're covered for that in terms of your coverage. Coverage questions should be addressed to the trust insurance experts, not us. We're risk managers. And so how much insurance is enough insurance? How much life insurance is enough insurance? It's a rhetorical question. So I think you have to be really careful thinking about what you're insuring against and what the likelihood of that is.
Okay. Eric, anything before I move on?
Nope.
Okay. So on a different topic, I know that we are considered healthcare professionals and that technically we should have everyone masked on our premises. At what link can I find this recommendation? Management at our building is requesting this info. Eric, can you sort of speak generally also to this?
Yes, generally I can.
Yeah, very general.
When you are a psychologist, you are a health service provider, and that means you're a health facility. And every state has a public health facility that creates rules. I think it depends on the state you live in, what the rules are. And I think we could probably make a geographical map that we could conceptually think there's some stricter and not so strict rules. But by and large, as I understand it, in most states, if your private practice is considered to be a healthcare facility and has to follow the healthcare facility rules, which in most states that I know of still require masking and cleaning and all those things.
Mm-hmm. Great. So moving back, thank you, Eric, moving back to the issue of telepsych, and Jeff, I'll send this one your way to start. What if a client is on vacation or traveling? Can a therapist see them for a virtual or telehealth visit while they're on vacation?
Well, the short answer is yes, but that's really a short answer, kind of as a foundation or to what Eric has already talked about, we've all talked about, which is depends upon the client, but generally the answer is yes. But if you have somebody who is, on antipsychotics, has a long history of suicidal behavior, is emotionally unstable, you may have to make a decision based upon that information. So how would you risk manage that? Well, if there's an emergency and you're on vacation in North Carolina, this is the hospital you're going to go to. You agree to do that. And this is the point of contact. And I will do this session. So you engage in realistic risk management. Most patients or clients don't need that level. So I guess simply put, it's a dynamic. The short answer is yes. And the actual answer is yes, but, or yes, however, you need to think about it.
Right. Well, and one of my favorite attorney friends says, you know, it depends. So Eric, you want to add something?
Well, I'm just going to say, basically, if they go on vacation for a week or two, that's one thing. If they go on vacation for 4 months, then you're back to the, you know, all of these questions involve continuums of facts, and you have to take each case individually.
Yeah, I think also I'd like to throw in, it depends upon whose needs we're meeting. When I've done these consults, I frequently get the feeling that we're meeting the therapist's needs to continue the contact with the patient versus the patient or client's needs to have contact with the therapist or patient. People want to travel and practice across state lines. I want to fix that too. I agree, but those are your needs. What's the need? The need needs to be based on, decision needs to be based upon the patient's needs.
Yes, no, that's a great point. And I think, again, we're hearing that there's not one answer. So we can't say definitively in every case when a patient's on vacation, yes, you can do it, or no, you can't, right? We're hearing that it's complex. And really there's 5 or 6, you know, factors that you have to consider and weigh them with the case specific facts. So this is a case where consultation is very important. Eric?
Whatever you decide to do, you may have to have very good documentation of your thinking process. Because if there's a problem, that's what people are going to look at.
Yeah, so documenting that clinical rationale for the exceptions, right? Why did I do this? What was your, not just what did you do, but why did you do it? And why did you not do the opposite? You know, like whatever you're choosing not to do, why did you not do that? How, literally, Eric, as you say, laying out that 9th grade algebra rationale. Okay, next question. Can you take into account that an in-person referral is likely not readily available, so that supporting a continuing therapy arrangement would be superior to insisting that the person find a new in-person therapist when there likely would be a delay? Eric, why don't you jump in there first?
I'm not sure what the question is exactly.
I think the question really is, if I'm considering seeing a patient in another state, what if referring them means that there's going to be a delay in them getting treatment, right? Because clinicians around the country are very full at the moment. Is that a reason to continue seeing them?
I think that what my sense would be that if there is you can create a rationale that says this person needs to terminate appropriately. I would like to make a referral, but I haven't been able to find one. It may take a month for the referral to take, and this person would be hurt if they had to wait a month. And so in that sense, I would continue. I said it would be okay to continue to work with them for a reasonable period of time to make sure the termination is appropriate. But there's a number of conflicting issues. How long did you know that the person was going to be moving? If you knew for 6 months, why are you waiting until the last week to decide that you can't find somebody? And those are the kinds of things that could get you in trouble. But generally, that's one of those things where there's a very good rationale for doing it, and the not doing it, the risk of not doing it is problematic for the client. If it is in fact problematic for the client, of course, again, if we've been saying in every single one of these, is it problematic for the client? What was the therapy about? Why does the client, why would a 6-week delay be harmful to the client? That's not automatically the case.
Yeah, and I'll add that, again, that's a case where looking at that other state's temporary practice law would also be important information to get, because it's possible, like if it's California, which offers you 30 days, that you could do some number of bridge sessions, right, to help that, and that you'd be well within the law doing so. It could be another state like Connecticut where it's not so easy to do that. So again, many factors to look at. Jeff, anything you want to add there?
Yeah, I think there's a third factor, which is the availability. If somebody is a patient who is moving to the Navajo Indian Reservation in northeastern Arizona, where there aren't any resources, that becomes an argument for justifying working longer with that client till the resources become available, because there aren't resources. There are a number of articles out there right now from lawyers who are arguing that, in fact, the current design of the rule system is limiting access to care, because if you're in a state where you're not licensed, you can't help that individual. And if there are no resources, you can't help that individual, is what the law kind of says. And I think that those become exceptions to lead you to make a decision to continue to see this individual longer till you transition them to somebody there, because they live there. And I don't think you can justify doing it ad nauseum if they live there.
Right. And again, consulting and documenting that you're consulting, because that's always going to help protect you in these complicated cases. Okay, here's sort of the reverse side of this. What if the provider is traveling? Can the provider see the patient from out of state if the patient is present in the state where the provider is licensed? I've sort of, Jeff, why don't you jump in on that first?
It's my turn.
Hey, I'm turning it over to you.
Yeah, I appreciate that. It's good. Eric wants to talk. You can stop now. This is interesting because there was just a posting on the Division 42 listserv about this, or the National Register listserv, I can't, asking about, if you're traveling, can you continue to do therapy? And it's the same answer that the people have been listening to. Of course, you're just going to be there briefly. That's a different thing than if you're going to be there for 6 months and try and do therapy in California where you're licensed, but you're living in New Mexico. If that's the case, you need to examine the temporary practice regulations in New Mexico, but that's different than if you're going to spend a week in Albuquerque and then go back to California. I think that the argument that the long arm of the New Mexico licensing board is going to reach out and grab you is just simply not correct. It's not going to happen. And so you make the clinical decision to take care of this individual, because we all know that continuity of care is important. And so it's once again a dynamic. A week or two, I don't think that's a problem. 6 months, I think that's a problem.
Right.
I might disagree with Jeff just a little bit here, because the rules are very clear. You are practicing where the client is. And if you are licensed in the state where the client is, there are no rules in any state that I know of that would say you couldn't do it indefinitely, because the transaction is considered to be taking place where the client is and where you are licensed.
That's under the civil law. I agree with you that, we wrote a paper about that, but there are licensing boards now that have declared that they have authority over practice outside of their state for their licensees. So, but again, I don't think you have to worry about a week or two, regardless of
No,
the nuances.
your basic point is well taken. I'm not disagreeing with that.
Yeah, and just to be clear, I mean, I think part of what we're hearing, right, is that some of this is changing, because like you say, Jeff, some states have now instituted new laws relatively recently in the last year or two. And so states are worried about this. So this again is a case where you want to consult, because there aren't black and white answers. We're trying just to give you a feel for things as best we can and help guide you along the way. All right, quick question, Eric, I'll send this to you. Can you bill insurance in the case of a patient who is outside of the state, or basically who's in a state where you are not licensed? Can you bill?
That depends entirely on the insurance company.
So the key would be to call the insurance company.
Yeah, you'd have to check with them or have your patient check with them.
Yeah, perfect. And this, Jeff, I'll send to you, but I think this is really important so we can clarify, because I think sometimes it's hard to get the clear message here. So the question is, when you say to carefully consider if this is an exception to continuing to see someone in a different state that we're not licensed in, are you saying we can then go ahead and continue to see the client outside of our jurisdiction without contacting that state's board and just wait and see if someone sends you a cease and desist letter?
The answer to that is absolutely not. I mean, you need to check on the law. That's not the little exception that we talked about here. It sounds to me like, I could be wrong, so I'm not maybe misreading the person who wrote the question, but they want to find a way to practice in another state and not have to be accountable. You can't do that. That would be briefly that you could do that, make a risk management decision about it. But if that patient is going to be there, you need to check on the temporary practice provisions of the state where the patient is located, just to see what they have to say. They may give you 30 days, like California. Georgia used to do that, but they don't. They're now a SIPAC. So it's not a simple answer to that.
Eric?
Let me go back to the case law, which basically says the reason for the exception is that the continuation of the services is necessary for the client's clinical well-being. So in most cases, I would agree with Jeff, but there's some cases where, let's say you've been working with someone for 8 or 10 years, they have, they are making slow but steady progress. There's no chance that they would accept a referral to somebody else, and they're in a different jurisdiction. I would argue that in some cases you could continue to see that person indefinitely, because that is what the exception to the rule implies. The longer you see somebody in that situation, the more risk there is. But
yes.
Not as a matter of, the law is not intended to be temporary. It's dependent on the services being, for example, let's say you're working with a couple who's divorced and their parents live in 2 different states. You can't do, and you're working with the kid. There's no way that you can do meaningful therapy in that situation without involving both parents, which means you would have to have one parent in a place where you weren't licensed. And that could go on for quite some time. If you try to do that kind of therapy with just the person that resides in the same state that you are in, you would be dooming yourself to an unsuccessful therapy, because the other parent will feel rightly that they aren't getting the same hearing that the parent who's in the state is in. And then the likelihood that the kid will get caught up in a divorce problem is such that, so in that situation, again, it's a factual situation. In that situation, I would say you would do it until the therapy is finished.
I don't
No other way
disagree
to
with
do it.
I'm going to interrupt both of you. I just want to add maybe, because again, what we're hearing is there's no one right answer. We can't, I do agree with you, Eric. In some instances, there are cases where I too would say, you know what, this is an absolute exception. There's very good reasons for this, and continuing indefinitely makes sense. However, there is risk when you make that decision. And it's not a decision to be made lightly or flippantly.
Yes, I
And
agree.
I think a lot of, I don't want to say a lot of clinicians, I know I've had conversations with a fair number of clinicians who just say, well, I've been seeing this patient already, or worse, I got the referral. This is what I do. Of course I need to do this. Of course it's in the patient's best interest. And that I think that question of, is it in the patient's best interest, needs to actually be really considered, not just a flippant, of course it is because I'm working with them, right?
Yeah, I think you're right. I just very quickly, when the listening audience needs to know, we field phone calls all day long with questions that are really exceptions. And so what do you do if you're a SIPAC provider, you're providing this family therapy situation, and one of the parents is living in a SIPAC state and the other parent is not? And I think any clinician would say excluding that parent in the non-SIPAC state is not clinically appropriate, but it has to be carefully thought out. And these things haven't been thought out with SIPAC. So you have to go like, I'm going to see both of these because clinically I need to do that. To exclude one of them because they're not in a SIPAC state, this is me speaking as an individual, makes no sense to me.
Mm-hmm. Well, yeah, again, I think it's complicated. I know Jana is coming on, so that must mean that we're close to time. I want to just wrap up just to clarify, because I know there is a lot of nuance here. So when you're considering cross-jurisdictional, whether it's within the states or across the, internationally, you want to think about several factors. What are the regulatory situation? Is there temporary practice law, et cetera? You want to think about clinical suitability. What's the risk for you and the patient? You want to think about length of time that you would be practicing in that other jurisdiction. You want to think about emergency and safety planning and billing issues. All of those. And lastly, we'll just underscore again, consult, because every case is different.